Let's go live now to my colleague Ayanda Mhlongo. Ayanda?
Still coming to you live now outside the Pietermaritzburg High Court, where the case against former President Jacob Zuma has just been provisionally adjourned to the 30th of November by Judge Madondo. As expected, as we were speaking throughout the morning, that it was expected, legal experts telling us that it was going to be a postponement today, but of course some interesting points coming out of court today insofar as the arguments from the state as well as the defense on the date, as well as some other issues that needed to be dealt with. There was the matter of the review application that we now know the state has abandoned, the defense, I beg your pardon, has abandoned, and instead they intend to file for a permanent stay of prosecution. You should be seeing now in your visuals former president walking out of the court, making his way across the courthouse to Freedom Square, where thousands of his supporters that began gathering from last night, growing since this morning, have come out here in support of Mr. Zuma, and he is expected, as now has become a tradition in this case, that he, after the court appearances, goes and addresses the masses that have come out to join him there. As we speak over and before we go to the podium where an official program will be happening shortly there, ANC leaders are here from the province of KwaZulu-Natal, led by the chairperson of the ANC there, Mr. Sihle Zikalala. There's also former ministers, other senior leaders of the ANC that are out here today to show their support for the former president. And as you watch those visuals, let me just chat to our advocate just to go through what happened very briefly in court today. Advocate Makosazana Mbonandi, thanks again for staying with us. We were, you had said in the morning, of course, as expected, it was going to be a postponement to allow the new defense team, Advocate Mike Henlin, to a time to familiarize themselves with the case, and indeed that is what has come out in court. But firstly, for the state, Advocate Billy Downer, he came in to say that they were ready and that the defense had enough time, and that they hope that within the 3 months from now to the 30th of November that they should be ready. But however, for the defense saying no, we still need some time.
Thank you for having me on again. Well, today we can say that it went as expected, apart from the fact that there was an abandonment for the review application. So quickly, the state's case today was that, yes, we accept that there's a change of the legal team. However, we do not think that a postponement to the mid of November, because that is what has been said by the defense team, is necessary for you to prepare an application for a permanent stay of the application. So yes, the defense and the states met beforehand, and they agreed to a provisional date of the 30th of November. What they are not in agreement with is that there's going to be an application for, they agree that there's going to be an application for a permanent stay of prosecution. They do not agree on the dates. The case of the state is that the defense, while the former president has parted ways with his former team, it shouldn't be that difficult to make an application for a permanent stay, because representations have previously been made, and that was the case of the state. The case of the defense, however, is that we want to prepare a thorough case, and we believe that we are going to be granted for several reasons that he mentioned, one being irregularities in the state's case, the investigation, and so forth. So for us to for us to properly prepare, we need to be given proper time. And if we postpone to a date which was between 4 to 6 weeks, we will not be ready then, and that will occasion further postponements, which is not desirable. And he did say that he's aware that the media has, as well as counsel before in court, has said that this is a delay tactic, and he assured the court and his learned colleagues that he just wants to prepare a proper case, and that's what eventually happened. With regard to the co-accused, counsel for co-accused said that what they want is because as we know that the NDPP is considering amending the indictments on the co-accused. So counsel just presented to the court that as long as that amendment is presented to them as soon as possible, they are flexible either way to present an application with or without the co-accused, or in a month's time, 6 weeks' time, or in 3 months' time. So they were very flexible on that, save for the parts where the state has to give them an indication when they can get that amended indictments. So the judge decided that okay, it is a new defense team. They do need to familiarize themselves with the case, and they do need to present a proper application if they so wish, and they need to be given reasonable time, and has decided on the 3 months, and they will be appearing on the 16th of November. So they've been ordered to prepare and file their papers before then, so that the court can consider this.
There is also that matter that they spoke about of the new affidavits that the state is in possession of the state, and the defense saying that they still need to see those affidavits, obviously, so that they're able then to compile or put together their application when they file it in court.
Yes, so the application is closely linked to the trial, so they would need to do proper preparation. If the state has new information and has new evidence, they would need to discover that, and they would need to, the defense would need to know what case they need to meet. So if the state has any new statements that might assist their case, they still need to let the defense know that this is the case that you are meeting, and that is what counsel for the co-accused was talking about.
I just want to briefly go back to, with regard to the application for the permanent stay of prosecution, and some of the points that were made by Advocate Henlins there, speaking about charge delay, a trial delay, and the pre-trial irregularities. Are these going to be the grounds or the points that they're going to make in their application? And just take us through that when they file that application for a permanent stay of prosecution.
Okay, and so a permanent stay of prosecution means if that order is granted, the court is going to stay the prosecution, and it's going to be lifted when both parties are ready for trial. So then we do not set down a date for when the matter will start. That gives the defense enough time to prepare. So if they are going to make that application, they need to convince the courts and present to the courts reasons why they need to, apart from the fact that it's a new team, why they need to fix all these irregularities and meet for conferences with the state, so that anything that happened prior, which would have jeopardized the case of the accused, is attended to before these cases are presented.
The other matter was that around Mr. Zuma's finances, and we heard from Advocate Henlins that regardless of what happens in the other matter that has been brought forward by the DA and the EFF, in fact, he said to the judge, we are here to stay.
Yes, that is what senior counsel said today. You'll remember, Anda, that the application for a temporary stay was the reason why there was a postponement, because it was likely there's going to be a review of that decision. That possible review has been abandoned, and they said that the issue of fees is no longer an issue. So whatever the courts in Gauteng decides on the issue of the president paying his fees or not, this team has assured the courts, and as officers of the courts, they have submitted to the court that they are going to stay regardless of whether the president has to pay his own fees or whether the court decides that the agreement with the states has to be honored.
Advocate, They spoke about, obviously, this case has gone on for quite some time, 17-year period, which is quite a lot. And he even said that there is a large number of documents that are currently with the former president's former defense team that still needs to be brought over to the new team. But looking at that mountain of paperwork that they need to get, and earlier on we were speaking about some people saying that these are deliberate delays on the side of Mr. Zuma and his legal team. Your view on that 17 years worth of that should obviously mean that they would need quite some time.
Well, it all depends on the legal team. You will recall that counsel for the accused said that as it is right now, they are preparing a chronology. A chronology is where you go through all the papers and you date it from the first occurrence to the last. And if it's been 17 years, you can just guess how many things happened in a month, how many happened in 6 months. So preparing a chronology alone is probably going to take them a while. So then they have to read them properly. Then they have to consider what to put in the application and then what to put in the trial if the application is dismissed. So it is safe to say that they do need an amount of time to prepare, and he has given an undertaking that they don't want to occasion more postponements. So they're given an undertaking that 3 months is enough, and the court has agreed.
The provisional date that has been agreed upon, the 30th of November, of course, the 16th of November will be for the permanent stay applications to be filed. But 30th of November, will this be the trial date?
Well, yes, it's a provisional date for the trial. But if the application is successful, then it will be stayed permanently until both parties are ready to proceed. But if the parties are not, if the accused are not successful, then that would be the date, because that is what the order of the court is.
But there was also talk of some time in the first quarter of next year that was raised by the defense. Probably, I guess, would that have been for the start of the actual trial?
That would be for the start of the actual trial, but you'll remember that as well as the application in itself is probably going to take a while because there are many presentations to be made, particularly if they're going to be presented for both accused. So it was saying it in two parts, that the application in itself is going to take time to be heard, and then a decision is going to have to be made. So it is possible that we are looking at next year. If the application is granted, then they are saying that we're looking at next year for the trial.
All right, Advocate Bonani, thank you so much for your time there. She's been with us from this morning, just sharing with us her legal expertise on this case. The date, 30th of November, we will be back here in court. That is the provisional date that the parties here, both the state and the defense, have agreed upon. And I guess on that day, it will then be decided insofar as the applications for the permanent stay. Also, we still need to find out on that day insofar as accused number 2 being French Arms Company Thales. Their representative, Christine Guria, she lives in France and travels from France to attend proceedings. She had been excused from today's proceedings, and her defense, they're representing that company, saying that they still need to be in contact with their clients about her possibly being here for that next appearance, and whether or not those two applications will be heard together. So a postponement, yes, but it had been expected to be a very brief appearance today, but certainly a lot coming out there from court with regards to this case against former President Jacob Zuma. I'm just looking across now at the Freedom Square, where the thousands of supporters of the former president have come from across the province of KwaZulu-Natal, as well as other provinces, as we've now seen whenever he appears, that crowds will gather in support. As I said, it started with that night vigil last night. Throughout the night, supporters were here. Once again, the march in the morning from Dales Park to where we are.